Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss various committee reports. In the last class, we have discussed the few committees. Today we are going to discuss Justice Eradi Committee Report 1999. Let us recap what we have discussed in the previous class. In the previous class, we have discussed Tiwari Committee reports and the background and context of the committee. Then we have discussed the mandate of committee. So what was expected from the committee, from the central government. Then key recommendations given by the Tiwari committee and how it impacted the legislation in India or policy framework in India. Then subsequent to that, we have discussed the Narasimhan committee reports 1 and 2. Narasimhan committee report 1 was given in 1991 and report 2 was in the year of 1998. Then we have discussed the objectives of these committees. Then recommendations given by Narasimhan Committee Report 1 and Report 2. Then we have discussed the impact of recommendations, how it impacted the policy framework in India. Then today let us discuss the committee, that is Justice Eradi Committee, 1999. So before that, let us discuss the background. So by the late 1990s, so India was facing the serious backlog of NPS and slow insolvency resolution process. If you observe 1990s, so many banking institutions, they were unable to recover the debts that they have given, and even our economy is also in it is in distress. So that's why even the insolvency resolution process is also very slow. And two major regime, if you observe at that point of time, includes Companies Act. So 1956, where we are having Company Law Board or CLB, it is also called as CLB. They are having provisions relating to winding up of the company. But the provisions relating to winding up of the company, they are all general in nature. So they are not exclusively concentrating on these NPAs or stressed companies. And even we are also having SICA. So as we have discussed even in the previous classes also, though the SICA legislation was enacted with the main purpose of rehabilitation and revival of the company and also to complete the process quickly, but the reality was that they used to take a number of years. There is a problem with the SICA. Then both the systems, if you observe, either under the Companies Act or under the SICA, both the systems were inefficient and fragmented, and I can say they are all time consuming. They used to take lot of time, around 5 to 6 years to settle one issue. So that's why with this background, the government thought we have to make some more changes so that the resolution process or the insolvency process must be completed quickly. So to address this, the Government of India, in consultation with the Ministry of Law and Justice and Ministry of Finance, they set up a high-level committee on law relating to insolvency companies. 1999. So it was chaired by Justice V. Balakrishna Eradi, so retired judge of Supreme Court. So they gave the recommendations. So before that, what are the terms of reference? So what they are supposed to consider. So this committee is expected to examine the law relating to winding up of the companies. So we are having provisions under the Companies Act relating to winding up of the companies. So is it appropriate? Is it sufficient in the present scenario? They are supposed to examine. Then they are supposed to suggest for consolidating and streamlining the insolvency process. Then recommend whether BAFR mechanisms under SICA should be continued or not. It is one of the reference point for them. Then align Indian insolvency law with international best practices, like you are having unilateral model law by that time. So we have to align our insolvency law with the international best practices. Then ensure creditor rights, because by that time actually our insolvency regime was mainly debtor centric. So it's not creditor centric. So we have to ensure that creditor rights promote corporate restructuring and speed up of the insolvency resolution process. So we have to ensure that the creditor rights are protected and we are going to promote the corporate restructuring. Okay, instead of going for only liquidation of the company, we should always try for restructuring. Okay, then even the insolvency process must be completed in a quick manner or in a speedy manner. Okay, so these are all the references, terms of reference. Now what they recommended, let us discuss the recommendations given by the committee. So first one, abolition of BAFR and AAIRF. Okay, so the committee recommended that BIFR must be abolished. Why? Because they have criticized BIFR for being debtor-friendly forum. Because mainly, as already I told you, it is debtor-debt-friendly. It is not creditor-friendly. So when a system is debtor-friendly, obviously they'll try to use this BIFR mechanism to unnecessarily drag on the cases to bypass the provisions. Okay, so that's why they criticize BAFR for being debtor friendly. Okay, then they suggested that we have to replace SICA 1985 and abolish the BAFR and AAIR. Okay, then they recommended transferring of all powers to single unified tribunal. Okay, so by that time actually already labor courts are there in the form of tribunals. Already tribunals system or tribunalization of the judiciary system is already started already by that time. Okay, so then they recommended that we need to have the NCLT, National Company Law Tribunal. Okay, then proposed establishment of specialized tribunal for revival and rehabilitation of sick companies and winding up and liquidation of the companies. So because previously we are having BAFR mechanism and we are also having separate mechanism. Okay, so we have to club these mechanisms, two mechanisms, and we have to replace everything with the NCLT, single mechanism, so that NCLT will take care of everything. Okay, then they propose that NCLT, because we are having BAFR and also CLB also. Okay, Company Law Board under the Companies Act and BAFR under the SICA. So these two bodies must be clubbed, and they suggested that NCLT must be there, must be replacing these two entities, that is namely CLB and BAFR. I can say in the place of AAIFR, it's not purely in the place. Okay, so if anyone is not satisfied, if any person is agreed by the decision given by the NCLT, then he can approach the NCLT, National Company Law Appellate Tribunal. Okay, so these are all the recommendations. Now, consolidation of insolvency law. So another major recommendation given by this committee is consolidation. Okay, so they recommended that we have to consolidate all the laws relating to sick companies and winding up provisions and restructuring, liquidation. We have to consolidate all these legislations. Okay, all these provisions, I can say. Then we have to complete the process in a time-bound procedure. Okay, so why? Because if you observe in SICA and CLB process, it used to take a lot of time. Okay, so that's why we have to ensure that the process is completed in a time-bound manner. Okay, so they have proposed strict timelines for admission of cases, within which time you are supposed to admit, and approval of revival scheme and liquidation process. Okay, and emphasize that whenever there is a delay is there, please remember the asset value will reduce, which leads to erosion of value. Okay, so that's why the committee recommended that you have to complete, we are expected to complete the process within the time limitation. Okay, then creditor-in-control framework. So till SICA we were having the debtor-in-control mechanism. Okay, so now this committee recommended that we are expected to shift from debtor-in-control to creditor-in-control. Okay, so propose a shift away from the debtor-in-possession model of BAFR. Okay, then recommended a creditor-driven process. Okay, giving banks and financial institutions more control over the insolvency process, because these financial institutions and banking institutions are the people who gave loan actually. Okay, who invested their capital. Okay, so they should have some control over the debtors. Okay, so that's why now this committee recommended we have to shift from the debtor in possession process to or model to creditor in possession model. Okay, then promotion of corporate restructuring. So instead of concentrating only on the winding up of the company, even we have to concentrate on the restructuring also. Okay, so they have promoted or they have advocated for mechanisms relating to debt restructuring, operational turnaround, mergers and amalgamations, early identification of stress. Okay, so these are all the various things which concentrate on the restructuring. Okay, so rather than only closing the company, we have to concentrate on restructuring. Then professionalization of insolvency process. Okay, so they stress that qualified professionals. Okay, so they are supposed to be prosecutor for insolvency professionals. Okay, then advocated for involvement of specialized agencies who can handle the restructuring and liquidation agencies, and they can do the liquidation process efficiently. Okay, then whether these recommendations were implemented or not. Okay, let us look at Companies Amendment Act 2002. So these recommendations were implemented and they were introduced under the Companies Act in the form of amendment, Companies Amendment Act 2002. What they recommended? Okay, in Companies Amendment Act 2002, Eradi Committee recommendations were included. Okay, like provisions for creation of NCLT, NCLT, they were introduced through Companies Amendment Act 2002. Anyway, so though it was introduced in 2002, we were unable to establish NCLT at that point of time. Subsequently only we established. We'll discuss later, okay, what is the reason behind it, okay. Then repeal the SICA, but please remember, though it was repealed 2002, but it never notified, okay. So they didn't came into enforcement until the IBC was came into picture, okay. Now, after the IBC came into picture, SICA Act was repealed, okay. Then, but the fact is that though Companies Amendment Act 2002 was passed, but legal disputes are there. So in the case of Union of India versus R. Gandhi, okay, so in this case law, the constitutional validity of NCLT, NCLT was questioned because previously Company Law Board used to be more or less purely judicial body, but NCLT is not a purely judicial body. It's a quasi-judicial body whereby both judicial members will be there, technical members will be there. So it was challenged before the Court of Law. But the Supreme Court upheld that NCLT and NCLAT they were valid, and we having proper safeguards are there in the NCLT and NCLAT framework, whereby administrative authority will not take over the judiciary. Okay, so judicial member is there in NCLT, and while appointing these judicial members also, court will interfere. Okay, so judges will be there while appointing the judicial members. So while appointing the members in NCLT, judges will be there. So the Supreme Court held that yes, there are certain safeguard mechanisms are there. So it is not constitutionally valid. Okay. Then let us revise what we have discussed. Okay. So if you observe, or let us conclude, if you observe the Justice Eradi Committee Report, okay, so it was a watershed movement in India's insolvency law reform. Okay. So it is like they recommended a lot of changes, I can say. Okay. So they have recommended. So if they were implemented in 2002 itself, I can say the insolvency regime by this time would have developed a lot. I'm not saying that insolvency regime is not developed right now, but okay, so it was developed in 2016. Instead of developing in 2016, if we would have developed in 2002, obviously a lot of differences will be there. But anyway, so they recommended a lot. Okay, so although its recommendations were partially implemented at first, then subsequently, please remember, actually these recommendations were the basis for IBC actually. Okay, so whatever we are discussing, we are going to discuss in the subsequent lessons. For all these things, actually Justice Eradi Committee and subsequently we are going to discuss BLRC Committee also. These reports have contributed a lot to the formation of IBC. Okay, then it addressed the systematic failures of BAFR. Okay, so we were having BAFR system at that time. So it addressed that. It is a failure, systematic failure is there. Okay, and they call for unified and specialized tribunals and laid the intellectual and structural ground for modern system right now. Okay, so for that they have laid down the foundations for that, whereby the process should complete within the time limitation. Okay, in a modernized manner, and it should be credit centric framework must be there. So these recommendations were in the Justice Eradi Committee. Okay, so these recommendations were actually incorporated in the IBC. Now let us discuss another important committee, J.J. Irani Committee, 2005. So when J.J. Irani Committee was set up, okay, so actually this committee was set up by Ministry of Corporate Affairs in the year of 2004, December. Then the chairman is Dr. Jamshed J. Irani, Director of Tata Sons. He was the chairman. Okay, so it was a follow-up to the Justice Eradi Committee. Okay, so and part of the Companies Act modernization process. Okay, so basically this J.J. Irani Committee was formed to modernize the Companies Act. Okay, so already we were having some recommendations by the Justice Eradi Committee. Those recommendations were incorporated as a part of Companies Amendment Act 2002. 2002. Okay, then to continue with that modernization, the government set up one committee under the chairmanship of Jamshed J. Irani, okay, who is the director of Tata Sons. Now let us look at the objectives of this committee. So the basic objective of this committee is to advise the government on a simplified, compact and contemporary company law. Government is expecting to have a simplified law or compact law and contemporary law. Okay. So what is the basic or what is the major area of concentration? Okay. So this committee concentrated on the promotion of good corporate governance. Okay. So based on JJ Irani committee only. So lot of changes were there relating to corporate governance in India. Okay. And to enable faster restructuring and liquidation, protect investor and stakeholder interest, then encourage ease of doing business. So ease of doing business is very, very essential. Why? Because if we don't have ease of doing business, okay, so then investors may not be willing to invest in India. So ease of doing the business and create a globally competitive environment for the Indian companies. So these are the basic objectives of the committee. Now let us look at the structure of committee report. Okay, the report was submitted in May 2005. Okay, so which covers multiple aspects actually. So which covers like incorporation and registration. So how to incorporate a company, how to go for registration of the company. Then management and board governance. So whatever the structure we are having, the management structure, and there should be independent director. Okay, so like that. Okay, the structure was actually recommended by the committee only, JJ Irani committee. Okay, then investor protection. So they were having the investor protection. So where central government has established the IEPF account, Investors Education Protection Fund. Okay, so these things were based on the recommendations given by the committee. Okay, then amalgamation and winding up. We are having some amendments are there relating to amalgamation and winding up. Okay, then they covered aspects relating to offenses and penalties. Okay, now let us look at the recommendations. Okay, so simplification of company law. So the basic recommendation or the major recommendation given by the committee, Irani committee, is the simplification of company law. Okay, so they recommended a single comprehensive model company law. Okay, so we are expecting or we need to replace Companies Act 1956. Why? Because Companies Act 1956, I'm not saying that it is bad law, but it is not modern law. Okay, so that's why we have to replace. Okay, if we amend, okay, so if we amend the legislations again and again, okay, so we may not be in a position to implement the law properly. Okay, so that's why, okay, the law should be flexible and technology driven to respond to the evolving business needs. As and when it is required, we need to be in a position to change the law. Okay, so if you observe Companies Act 1956, majority of the cases, the government, they don't have power to make the rules. Okay, so everything is there in the law, that is in the act only. But if you observe 2013, Companies Act 2013, okay, so majority of the cases you will find a provision stating that the central government is having power to make the rules and regulations as may be required, as and when it is required. Okay, so delegated legislation. Okay, so the committee recommended that we need to have the delegated legislation so that it is not practically possible for the government to place everything before the parliament. So that if we can have a legislation which is more or less like enabling provisions are there. If you have more enabling provisions whereby if central government is having power to make the laws or power to make the rules, then depending on circumstances as the business is evolving, you can make the rules and regulations accordingly. Okay, so there is a basic ideology behind the JJ Irani committee. Okay, then fast track mergers and acquisition. Okay, so they propose fast track mergers for the purpose of merger process for wholly owned subsidiary and small companies. So that means a wholly owned subsidiary can merge into its parent company through fast track process without following without getting approval from the tribunal. Okay, so they can go for merger. So this was proposed by JJ Irani, and even in case of small companies also, without following the detailed procedure, you can go for fast track mergers. Then suggested no need for court approval in such cases. That is, in case of fast track mergers, you need not to go to the court. You just complete the process of board meeting and shareholders meeting, and file it with the ROC. So that is more than sufficient. Okay, so this is one of the major recommendation. Even now also in the Companies Act we are having section 234. Okay, so Companies Act 2013, section 234, sorry, 233. If you look at section 233, we are having provisions relating to fast track mergers. Okay, then revival and rehabilitation of sick companies. So it supported the shift from debtor in possession under the SICA to the creditor in control model. Okay, so stress that insolvency law must be time bound. So this committee recommended that the insolvency law must be in time bound, and they recommended to promote early detection of sickness. So instead of responding after the sickness, if you can respond in advance, then we can protect the economy as a whole. Okay, so we can protect the company. Okay, so and allows for professional resolution. Okay, so we are expected to have professionals for resolution. Okay, so back the proposal of Justice Eradi Committee to empower the NCLT. So actually by that time we have to remember, even during the JJ Irani Committee also, NCLT it was not realized actually. Okay, so even this JJ Irani Committee also backed the proposal given by the Justice Eradi Committee, whereby they recommended that NCLT must be the specialized body which is dealing with all the cases relating to maybe rehabilitation, winding up, etc., etc. Okay, then single forum for adjudication. Even JJ Irani Committee also recommended for single forum, that is NCLT. So reinforce earlier recommendation for establishment of NCLT and NCLAT. Then suggested the merger of CLB, BAFR and High Court powers. Okay, so previously we used to have powers with the CLB, BAFR and High Court also. Okay, so all these three powers with the NCLT. Okay, so that NCLT is the specialized body which can deal with the Companies Act matters as well as insolvency matters. Okay, then the provisions relating to winding up, restructuring, merger and amalgamation, revival of sick companies, everything has to be merged with the NCLT. Okay, so already anywhere now under the Companies Act we are having powers with the NCLT only. Then let us look at other recommendations. Corporate rescue mechanism. So stressed on creation of structured corporate rescue mechanism. So whereby they suggested early warning systems whereby debt restructuring and credit solutions must be there. Okay, so encourage a framework which is similar to the international unilateral model law. So even our country should have, because internationally every country is following more or less unilateral model law. Even we should follow, so that if the legislations are similar in each and every country, so the investors will be, it is very easy for the investors also to invest. Okay, so that's why they recommended framework which is similar to the international standards like unilateral model law. Okay, then they advocate, this committee, they advocated the use of company secretaries, chartered accountants and cost accountants as specialized professionals. Okay, because these people, if you observe their syllabus also, these people are specialized in the corporate matters. Okay, so maybe company secretaries, corporate law firms, corporate law, whereas the chartered accountants are relating to accounts and auditing, and cost accountants relating to costing. Okay, so they are all specialized professionals. Okay, so that's why this JJ Irani Committee advocated that these professionals must be given priorities, and they advocated that we have to use these professionals. Okay, then prosecutor to the concept of insolvency professionals under the IBC. Okay, so under the IBC we are having the concept of insolvency professional. Okay, so this actually the recommendations given by the JJ Irani Committee actually which acted as a I can say founding stone for the IBC, founding stone for the insolvency professionals under the IBC also. Okay, then let us look at other recommendations. Okay, efficient winding up and liquidation. So recommended time-bound procedure with the use of technology and professionals. Supported administrative liquidation in small cases. Then stakeholder protection. So emphasized on balancing creditor rights with minority shareholders protection during the insolvency proceedings. So because this committee recommended that previously we are having debtor control mechanism. Now we are shifting to, we have to shift to creditor control. But when you are shifting to creditor control also, you should ensure that minority shareholders' interest must be protected. Okay, so this committee recommended that there should be a mechanism where we are protecting the minority shareholders also. Okay, now what happened based on this committee. Okay, so the JJ Irani committee was a crucial milestone, I can say, because if you observe the company law before JJ Irani committee report and after JJ Irani committee report, lot of differences are there. Okay, so it was crucial milestone in India's transition to a modern, creditor-friendly and time-bound corporate insolvency regime. Okay, so build upon the JJ Eradi's committees. Okay, so actually it was acted as these recommendations. They acted as a foundation for Companies Act 2013. Okay, actually we were having Companies Bill also before that actually, but we were unable to pass the bill anyway. So subsequently we were able to pass the Companies Act 2013, and it paved a way for even insolvency bankruptcy code also in 2016. Okay, now let us recap what we have discussed till now. So in this lesson we have discussed about the actually two reports we have discussed. Okay, so one is Justice Eradi Committee 1999 and another is JJ Irani Committee. So Justice Eradi Committee, they have examined the laws relating to winding up of the companies and creation of NCLT. So NCLT was actually supported by the JJ Irani Committee. Then consolidation of the insolvency law, they recommended that we have to consolidate the law relating to insolvency. Even if you observe our IBC also, in the next lessons we are going to discuss, even if you observe IBC also, Insolvency Bankruptcy Code, the first part itself says that it is a legislation to consolidate the law relating to insolvency in India. Okay, so it is a consolidation law. Okay, then they recommended the time bound process for the winding up of the company, restructuring, rehabilitation. Then promotion of corporate restructuring. So corporate restructuring is also promoted. Okay, so I mean they recommended to promote the corporate restructuring. Okay, then subsequently we have discussed the JJ Irani committee report. So it was given in the year of 2005. So if you observe JJ Irani committee report, so they have introduced the concept. They recommended the concept of fast track mergers and acquisitions. So actually now that is the basis for section 233 of the Companies Act 2013 right now. Okay, so fast track mergers were recommended. Then they supported the shift from debtor in possession to even, I mean, as Justice Eradi committee also recommended from the debtor in possession to creditor-in-control model. Even JJ Irani committee also recommended the same thing. With this, we have completed JJ Irani committee also. In the next class, we will discuss other committee reports.